I'm going to talk about the civil service in Portugal, and I'll try to do a psychoanalytic approach. An attempt of commenting a law problem, according to a cultural point of view. But first, let me tell you that it's great that the transcontinental lectures are back. And I have to say that it's for me a pleasure and an honor to do this inaugural lecture. And beginning to speak by methodology, I'm using here the cultural method to approach law problems. That is the use of a cultural view or another scientific approach to study law, following some theoretical recommendations, some made by Habermas that considers law as a cultural science, the other ones coming from a group of mostly American professors who defend what they call the critical law view of philosophers or the postmodern jurisprudence. And as you know, I've been using this methodology for some time, and I think it's particularly adequate to study administrative law, considering its evolution from old times to nowadays. So now going to the point and talking about the civil service in Portugal from this kind of psychoanalytic approach, I must begin by trying a preliminary diagnosis and saying that looking at the past, we may verify that the civil service has been always characterized by a kind of schizophrenic dimension. And this schizophrenic dimension is the consequence of the traumatic facts of its difficult childhood, as I explained in my administrative law in the couch of psychoanalysis, because in all the countries that integrate the family of the French administrative law models, and in that model I include Germany, Italy, Spain, and Portugal, there were some facts, some constitutive facts that created this kind of traumatic circumstances that give rise to problems nowadays. And namely, I would stress two traumatic facts. First, the creation of the administrative courts as administrative entities and not judicial ones. They were, at the time when they appear in the 18th century, considered as a part of the administration, not a part of judicial system. They were constituted not by judges, but by officials. And at the same time, there happened that we assisted to the birth of an aggressive model of administration, Eingriffsverwaltung, as Baroff called it. And this Eingriffsverwaltung had to do with the idea that the administration, when had to take an action, would conflict necessary with the rights of the people, should make a lesion, a problem in relation with this kind of rights. And that was something that had to do with the authoritarian part of the liberal state but also with other authoritarian regimes that were at the time, like in the Prussia of Bismarck. So this created, in the beginnings, a kind also of an authoritarian administrative law that was designed to protect the administration and not the individuals, as it happened very clear in the Blanco judgment that was a kind of birth certificate of administrative law. But then at the same time, we have another traumatic situation, because after the revolution in France, we have, after Napoleon, the beginning of a French notion of public service. And public service has been considered and then theorized afterwards as a kind of employees that were exclusively dedicated to prosecuting the public interest in the exercise of the administrative power. They should be neutral towards political parties and the ideological influences. And this model of service, of public service, that was instaured first by Napoleon, was theorized in the beginning of the 20th century by Maurice Aurieux, with his theory of the civil service as a part of the administration, seen as a kind of public service for everybody. But this Napoleonic model of civil service as a profession was also combined in the end of the 19th and the beginning of the 20th with the German concept of special authoritarian relationships inside the administration. That was a thing that was invented by Otto Meyer, one of the fathers of administrative law, that considered that among administration, we could only talk of internal relations. There were not law relationships. And he called those relations special power administrative relations. And those administrative relations that existed, according to Otto Meyer, also in the civil service, were characterized by the fact they were not subordinated to law nor to subjective rights. These traumatic events and the beginning of administrative law conducted to an authoritarian notion of public service, typical of the liberal state in the countries of the continental model of the 18th and in the 19th centuries and beginning of the 20s. If that is a general problem that afterwards had an evolution that we're going to study, if we look now at the situation of the Portuguese public administration and civil service in a nutshell, we can consider a 4 periods evolution from its beginning until this moment. There was a first period that begins in 1844 after the liberal revolution of 1820, and that goes until 1933, where Mozinho da Silveira, a minister of finance, created the Conselho do Estado at the light of the French Conseil d'État in 1844, and by that, the French system of administrative law has been adopted in Portugal with all its consequences. We have then a second period beginning in 1933 and going until 1976, where during the dictatorship that existed in Portugal in that period, the French administrative law system was kept. even if it was called or so-called as liberal, that authoritarian perspective he also had was good for the regime, and the regime imposed his authoritarian vision through the principle of obedience to the hierarchical superior. Despite Marcelo Caetano, that was a law professor in my faculty and was the weight of the dictators, somewhat surprisingly, expressly reject the Otto Meyer's theory of special power relations. But if he rejected the theory as a whole, he took from Otto Meyer that idea that the order given by a superior, an hierarchical superior, should prevail against the law. Then we have a third period that goes from 1976, after the Constitution, until 2004. And we must say that the Constitution of 76 was a consequence of the Carnation Revolution of 74, was the instauration of a democratic regime with some problems of transition and some circumstances, political circumstances that influenced the Constitution between 74 and 76. But it was clear that the Constitution established from the beginning a democratic model of administration based on the principle of legality, which prevails even over the hierarchical duty of obedience. And the Constitution says expressly in the Article 271, number 2, where it's completely abandoned the theory of the special power relations, and the obedience has to be compatible with the principle of legality. Otherwise, there is no principle of obedience for a civil servant. And the public service model is maintained, and the access to the civil service, according to the law, could occur in that period in two ways: by an administrative act or a public contract. And here we also assist to the attendance, a dualistic attendance that appoints for the schizophrenic phenomena I was talking in the beginning, in this kind of different ways of access to the civil service. But if the model now was democratic, and that was also the model of the Constitution, let us say that it was compatibilized with the French-German system of public service, and until 2004, the things did not change much. Even if there was this kind of dualistic situation, in some cases there was a contract, in some others there was a contract, and also a problem of compatibilities among rights and duties in this kind of both figures. There had some dispositions that were pure public law, and others that were inspired by labor law mainly. But after 2004, we change the system rather radically. And if we talk about the change, we have to talk about two periods, one from 2004 to 2014, and one that goes from 2014 until now. And this reform of the civil service changed radically the system, and seems to be based on two arguments. First, the flexibility of private law in the application what was called the new public management, something that was very popular in the beginning of the 2001 century, and it has been applied all over Europe, in Germany too, and other countries, and introduced more flexibility to the French traditional system. And then in Portugal, there was also another argument for this change. That was the argument of comparative law, and had to do with integration in the EU. And the argument used was one of the Italian model that was considered as a reference. And it was very funny that this system, that this argument was used, because I was recently in the month of December in Italy, doing a conference in Milano, and I could discover that there is no Italian model soever. And from the point of view of Italian law, the models succeeded after the beginnings of the 19th, and no one of them had a big duration. They were applied for a short period and then replaced by other systems. So it's impossible to talk about an Italian reference when this Italian, according to the Italian law professors, does not exist. But this situation created a kind of much more schizophrenic situation than it has been before, because after this reform, the way to access the civil service is now a unified contract for all kinds of public employees. And this new contract is named Employment Links in Public Functions. And that creates a kind of private-public employment relationship that is indeed very schizophrenic. And if you look at the name, we immediately discover it, because it says that it creates, it is called as employment links. So the idea of employment, the idea of a labor relation is something that is now configured by the law, but immediately after, the name speaks about links in public functions. So the idea that as it happens in lots of fields of modern administrative law, there is really a mixture of public and private law. But moreover than that, the general regime of work in public functions applies not only to contracts that were signed after the date on which the diploma came into force, but also to all contracts signed before in retroactive terms. It happened with me. I was going to bed in the night having a public contract, and I woke up in the following morning having a contract that most of the people told me it was only a private contract in a way similar to the labor law contracts. So this means that there was a new unification of the global regime of contract law that applies now to all the civil servants. But we must say that at the same time, and this is another sign of schizophrenia, it had some limited exceptions that were related to the exercise of sovereignty functions. For instance, police, armed forces, independent administrative entities, government, and some ones that cannot be explainable very well, because if I can understand the police and armed forces, I have some more doubts about the other so-called exceptions. So the schizophrenic situation begins to appear with this way of entering in the public service. But we have to say also that this contractual regime mixes private and public regulations, mix private, the question of labor rights and duties, with public regulations, like the question of functional duties, like the duty to obey. And that created even more or accentuated even more the situation of the schizophrenia I was talking about. And this kind of law also created following situations also of schizophrenic nature, like the one that can happen between two employees performing the same tasks in the public service, but to which two different legal regimes may apply if the same task executed by both is performed in the frame of an entity included or not in the exceptional regime. So if it is included in the exceptional regime, it has a public law, it is ruled by public law, and it should go through the administrative courts. If on the other side, it's considered to be in the general situation, it is regulated by labor law, and it would be decided by a regular court, judicial court, as constitutional calls. And this duality of regimes brings together also duality of jurisdictions. Because as a matter of fact, all the administrative employment contracts litigation should fall according to the law in the jurisdiction of the administrative courts. That's what say Article 4, number 1 of the statutes of the courts. But that would be the case if there was not an exception clause of the number 3 of the same article that excludes all of them of this regime. So according to this West norm, it is excluded from the administrative court jurisdiction the assessment of disputes arising from work contacts, with the exception of disputes arising from the public employment relationship. So the majority of the contracts are now considered private and ruled through labor law and running the litigation running through the judicial courts. And there are some exceptions that are considered as public one that have a special regime, and they are run and their conflicts are solved by the administrative court. Therefore, although apparently included, most public service contracts are excluded at the same time and with the same article from the jurisdiction of administrative courts through a double negative formula. Doesn't it seem like a very schizophrenic normative formulation to you? Or it's just me? Not to mention the problems of qualification of civil service contracts due to its schizophrenic nature, which can be considered as either private or public law. In fact, nowadays, the doctrine of private law tends to consider all the civil service contracts, with no exceptions, as a part of the private contracts, with some specificities for the ones that have to do with public function, sovereignty for functions, let us use the term. So they call it, and I was checking in the manuals and in the treaties on the topic written by my colleagues of private law, of labor law, and they characterize the civil service contract as a kind of special modality of private labor law contracts. And they deny all the relevance of public regulations, and it has a consequence. Nobody talks about the right to obey. And that may be a problem if we look at the exercise of the public service, because it is correct, the idea that the duty of obedience cannot prevail against the law, but the duty of obedience seems to be necessary to the performance of the public administration. So this is a situation that, can be seen also in another view, because the publicists like myself tend to defend that even those contracts that have most regulated by private law, we cannot forget the public law, and this kind of mixed situation creates a figure that even when it has a regulation from the private law, it can be considered still as a public contract, public procurement, a special kind of administrative law. And if we take in mind what Maurice Oliu said in the beginning of the century, this kind of mixtures between private and public law are not in conditions to affect the administrative nature of some contracts, even because that's becoming, in lots of fields, more and more normal, this kind of situation. So from my perspective, I think we should try to come to this kind of eclectical solutions that combine different regulations, but tends to give some primacy to the elements of nature of administrative law for the exercise of the public administration. But that's not the only question I wanted to bring to you here with this disruptive conference. Because nowadays, and it's a rather new tradition that is arising in Portugal, we are beginning to attend another schizophrenic question, that is how to qualify the civil service in Portugal, taking in consideration some other relevant changes occurred in recent times. As we've seen before, coming back to the history, Portugal adopted the French system of career of the civil servants, meaning that the public agents are independent in the exercise of their functions, and there is no spoils system like in the American system. That means also that the changes in the government among us do not mean a change in all the administration bodies and services. And there is a situation of continuation of civil service. There is tradition of the French model, and that is rather different from what exists in the Anglo-Saxonic countries that have different traditions. But having said that, we can say that may characterize in a general view the Portuguese way of considering the civil service, we also need to consider two new phenomena that arise today. And that in the conference I made in Milano before Christmas, I discovered that are similar also to other systems like the Italian. Even when in Portugal, special, the second phenomena we'll talk about has a dimension that seems to me to be rather worried, creates some preoccupations for the lawyers and mainly the public lawyers. The first phenomena is the increase of the numbers of senior officials in the top places of public administration who became political appointees. And these current trends, if it continues like that, and if it continues growing without limits or control, can jeopardize the qualification of the civil service system, bringing it closer to the Anglo-Saxon one. Let us say that in Portugal, if there was an increasing of number of this kind of situations, at the same time, there was created a system of access to these top administration jobs that creates a kind of competition, and there is a neutral commission, not a non-governmental commission that deals with these nominations, and it's supposed to choose 3 candidates from which of them the government will choose just one. But there is a pre-selection of 3 candidates. And if it worked really, and it was not not in sometimes put away, that could create some obstacles to a certain partidarization that we are seeing in our public administration. And nowadays in Portugal, there is a crisis. It's not a political crisis. The government has an absolute majority. But we are attending every day in the news to inquest commission of the parliament to the activities of TAP, the Portuguese fly company that has been nationalized by this government. And we discover that nothing that happened in that nationalized enterprise has to do with the public management. The orders are given and nobody knows where they come or how they could be applied. We discover that 1 month ago, the CAO of the TAP was dismissed by the minister when it should be dismissed by the public entity that is a public enterprise that cannot be ruled by the government. So we discover that this kind of idea of a neutral administration, neutral to politics and neutral to ideology, as nowadays in Portugal, bringing a crisis, because we cannot say that from the strictly political point of view there is a crisis. If you look at the polls, that absolute majority that the government should have has not any longer. Or if there was any elections, it would disappear. So that's a problem for the democratic regime, because the idea of administration that is controlled by the parties and there is not neutral, there is not independence as it was the French way of administration, can be dangerous for democracy and for the constitution as itself. But there is another problem that, in my view, is even more dangerous and even more frequent, because the other one, we say, well, it's still limited, even if now we have more and more situations where these things happens. But still, it's a limitation that is determined by the principle of legality. But we have now the creation of a new kind of political functionaries. Because if you look at the government, there are the members of the governments, and then we have, I would say, thousands of advisors and assistants that are not members of the public services, not politicians, and they have a relationship based exclusively on the public trust of the members of the governments or the public trust of local authorities. And this situation that is quite new and was a consequence of the laws of the that create the most close governments, because in Portugal, according to the constitution, the composition of the government depends on its own law. So its government changes the law. That recent tradition creates a situation that is not, let us say, healthy, because this trust, public trust on this kind of political functionaries arise due to the distrust of the government and the members of the government towards public officials in service at their own offices. And that, in one side, it means that the offices of the ministers and also the offices of the mayors increase every day, and they may have numbers that are really strange if we consider that we have at the same time the civil servants doing their job or supposing to doing their job, but they are not doing it because of this kind of political employees. But which is, in my view, even more problematic, is that this situation now, conducted by those laws that were made by the most recent governments, that these new political employees are not limited to assisting in the preparation and the execution of government decisions, but they can acquire delegated powers of the members of the government to act in lieu of legitimate governments. And that's something that seems to me to be really dangerous for democracy. Because I could understand the assistant in the preparation of the decisions, the assistant in the execution. Well, I would say, well, it's too much. They have too much people. But it's something that we can understand in a way. But the idea that these new political employees can decide replacing the member of the government that can give them the power to decide, that is something that we are used to see in the American system, in the spoil system. It's not typical of a French one. And this is even more dangerous from the point of view of the rule of law, since these political officials do not respond institutionally to the legislative assembly, as do the members of the government, nor to the public administration, because they don't belong to the public service, nor to the courts, because they only answer and in a personal capacity before those who appointed him. That seems to me something that is really very dangerous and can put in danger the way our democracy works and the way of our civil service was conceived. So these two current phenomena are responsible for another schizophrenic situation related to the public administration that does not really work like the French way, nor to the American way. In conclusion, there are so many symptoms of schizophrenia that the only solution is to start the psychoanalysis sessions immediately. And bear in mind that this is a lifelong problem, since there is never a definitive and complete cure for psychical disease. That's it, my friends. Now I'm very pleased to hear your questions and try to answer the best I can. Does any student want to ask anything about this problem? It seems not. Let me see the chat, but I don't see, well, just the answer of Andrea.
Well,
Burn, my dear friend.
I'm a kind of student, since I'm private. I'm in the private law and not at all
not at all.
administrative law. So for that reason, I may ask a question furthermore, because I can't stay very long tonight. For other reasons. Well, I like your speech very much, because I have a distrust from the side of economic law against too much mixture between private and public principles. Of course, I have to do with it as well in competition law, where it's, let's say, from the other side, that of course we need the state power in order to get rid of cartels and such things, or get real strong influence on markets like that. So there is that kind of mixture which is necessary. But we do have the same phenomenon in administration, by the way, maybe not as strong or problematic as in Portugal, but it was publicly criticized quite a lot in the recent years, that a lot of money was spent for these advisors, for these attorneys in service for public service, although they have their lawyers, of course, as well, and for other private kind of assistance, which at the first hand, of course, has its reasoning by that it is less dangerous for an administrative unit to outsource their decision in that way by just a contract, and then they, of course, they can claim their advisor if something happens wrong and it's not the fault of the official. So I think that there are some screws there, of course, which are matter and handled by administrative law, first of all. To change that situation, maybe the situation you called very drastically schizophrenic. Thank you so far. If you allow the remarks and
Indeed.
questions of a private lawyer.
No, indeed, great. And they are very adequate. I agree with you that we need to have some public law in private matters, and also some private regulations in public matters. And traditionally, we consider that the civil service contracts were a kind of special administrative contract that in some parts the labor was influenced by labor law because there was a work relation, but there were all the others regulations that had to do with public service. And the problem with the situation now in Portugal is that this mixture, since it is too much and nobody knows how to qualify it in the end, it creates a problem of qualification and a problem for the cuts to be applied, the law that is going to be applied, the cuts, and so on. So it can become a problem for public law. So I agree with you. By the way, there is a joke I used to say to my students that is based on Montesquieu, l'esprit des lois. It says that being good is good, but being too good is bad, because it means that you are an idiot that are not able to control your goodness. And then he concludes that because of that, we have to discover that we need limits for everything, and even the power needs limits. And I think it's a wonderful saying, because everything that is in excess cannot be good. It turns in something that can create a bad situation. And indeed, I'm glad that you say that this situation is being considered by public lawyers, because the public lawyer, the German public lawyer that was in Milan, I won't say who he was, did not recognize it and said, well, let's say, but I understood, and I had also this feeling before, that most of these problems are similar, and they have common roots. And in a way, it's not bad, this kind of changes between the French model and the Anglo-Saxonic, but we need to keep the limits. We need to keep the main measures of each system, and not creating a kind of confusion between the law that is applicable. So I agree very much with what you said, and I thank you very much for that.
Thank you so much.
Thank you. Okay, so if you need to leave earlier, and I see no more questions.
Well, actually.
Demetrius, great. Go ahead.
Well, I thought since the topic of schizophrenia came up, who else would be entitled to talk about that than you know, the Greek participant here. So I actually saw that one also coming. Thank you very much. Indeed, it was a very interesting lecture, and I learned a lot. And of course, you're perfectly right. The problem which you depicted with the advisors in other parts of the Mediterranean, they are called, like, well, to transfer it, golden boys or golden girls, something like that. More golden boys, actually. But I wanted to ask, since in other parts of the Mediterranean, quite often, when there is a change of government, the complete civil service participants seem to be exchanged for many years. And I'm not going to mention any names of countries involved. How was that possible to achieve that in Portugal? How did you do that?
Well, it's a good question that I cannot answer. It has to do with, with application of a new solution and the tendency to find the easier way of doing the things. And then we'll see. There is something very typical of the Portuguese, and not to think of all the consequences of his present acts and expect they turn on well in the future. So perhaps that could happen. That could have been the case, because in the beginning, it did not seem problematic. It was something that was quite limited. And when the point we discovered that is not as limited as it was in the beginning, it's already late to put an end to it. So probably that can be an explanation, but I did not study it from the sociological point of view, but you have a point. That's an interesting question that next time I can also consider.
It is really impressive, I have to say, since a good deal of other, especially Mediterranean countries, have struggled a lot with that topic. Mainly those ones who experience to have two very intense political poles interchanging at the helm of the government. So very impressive. Thank you very much.
No, it's me that have to thank you for being here and to organize all this. By the way, it's a great achievement, and congratulations. It's not easy to put on such a program like you did, and that's something that in the Alpes family, we are thankful to you and to all the others, but to you in particular. Okay, so it was great being with you all, and I think we can finish here this first lecture, saying again that it was a pleasure and an honor being with you, and especially being with my dear good friend and colleague, Professor Ben Opperman, and my dear good friend, Dr. Dimitris Parashut. So
I wanted to be with you at least at the start, so I can't be with you at any of the sessions. So at some maybe, but I think it's important at the beginning, so to give some support for the thing, which I think is great. So.
Thank you very much. Thank you very much. And I'm seeing here a heart from, I believe it's a Turkish student looking at the Omar F. Biwir. And there's another Jan Prestavon who says it was a pleasure listening to you. Thank you very much to you all, and have a nice evening.
Same to you. Bye.
Thank you.